what to do with it, or frankly, they're just ignoring you. Okay? Now, HOA arbitration. So we talked about your disputes with your HOA on things like they're not following the governing documents, they're not giving you records, things like that would be subject to a pre-suit mediation. However, when you have things like this, where you have, for example, an election issue, DBPR is uniquely situated. They know this. They do this day in and day out. They know how to look at the proxies if you're in an HOA. They know how to look at the ballots if there were ballots that were rejected because the outer envelope in the condo association wasn't properly signed. DBPR is in a uniquely qualified position to be able to cover that. I don't know. I think when you tip it. Okay. Oh, there we go. So DBPR is in a uniquely qualified position to handle those election disputes. So make sure you file a complaint with DBPR if you have an election-related issue.
Okay, so just so it's clear, the DBPR only handles these few categories of issues. And those are the ones that are on the slides. We will send you the slides if you want afterwards so you can remember. But DBPR can't handle much more than those few things, except if this new law that Representative Borja helped get passed by the legislature gets signed. So at the moment, there's not a lot the DBPR handles. Okay, last resort is litigation. But we do not recommend this option because there is a rule called the business judgment rule that applies to boards of directors, and it says that if a board of director member is acting in good faith, even if you disagree with what they're doing, they are allowed to make those decisions, and the courts will not let you proceed with a lawsuit. There are only exceptions for bad faith, crime, illegality, or self-dealing. Okay, what does bad faith mean? Bad faith is the kind of thing that your heart tells you is wrong. Like having a no-bid contract with an unlicensed vendor, or raising your fees and charging you huge assessments without spending the money on the things that they were supposed to spend on. Taking revenge on somebody who they beat in an election that they didn't want to have to run. Those kinds of things can be bad faith. But the courts make it very difficult to overcome the business judgment rule. The other thing is that there are expenses associated with litigation that you have to pay out of pocket. And you can win back your expenses if you win the lawsuit, or oftentimes if you settle, you can include the expenses as part of your settlement. But it is very expensive. Our average lawsuit has expenses of $50,000, and our recent condo lawsuit has expenses of like $200,000 trying to seek a receiver to be imposed, and it's still going. It's still expending legal fees. So if you want to file a lawsuit, you have to be mentally and financially prepared for the risk that not only will you pay over $100,000 in legal costs, but if you lose, you would be responsible for the other side's legal fees. And I'm sure if you have been looking at your association's spending and budgets and being concerned about that, you will notice that the lawyers that defend associations charge a lot of money, right? Like we have an opponent that is an association law firm, And their fee, we see their fees because our clients who are here today have pulled them out of their records, and they're 3 times as expensive as what our fees are. But because they have the money of the association behind them, they can spend that. So litigation is not your best choice. Unless you're enforcing a DBPR decision or appealing a DBPR decision. But again, this is super risky. The judges want to enforce the DBPR's decision. They like to defer to the DBPR. So it is a very risky choice. For homeowners associations, as you know, the only issue that the DBPR will consider is that election and recall issue, right? So regrettably, if you live in an association of single-family homes, your only choice would be litigation or election, which is less expensive but more time-consuming. And the problem I also want everybody to be aware of is that if the association hires an outside investigator, even if this person is not really impartial, they can invalidate your lawsuit at the very beginning because it shows the court that they had an impartial third party evaluate the claim, and the impartial third party said that there was no claim. So this is something to be concerned about when you consider filing a lawsuit. And for that reason, we only recommend lawsuits in very severe situations, like the hammock situation, like you have major evidence of fraud or spending money on personal things, cars, personal taking of money, like reimbursement fraud, things like that. Okay, so something has to be as bad as a criminal action to want to litigate over. Do you want to add anything?
Yeah, and it's not to say that you don't have the remedy of going to court. You do, but we feel like we're doing service to you if we're not telling you that if you sue your association, you're probably in for a long haul, and you're probably going to be out a lot of money. And even if you win, wonderful. It's wonderful if you win. You get your attorney's fees and costs in circumstances back. But you're going to be in a situation where you are, in essence, funding a lawsuit against another side that it feels like they have an unlimited pocketbook. Why? Because they're pulling the money from all of your association dues to fight you. So we just suggest that you try to do sort of the easiest path first, and the easiest path first is getting control of that board. So whether it's through a recall or an election, that's usually your fastest and cheapest way to create change in your association and get your association on the right track.
Okay, before we take questions, I just want to say Victoria Morton here is a certified association manager. She's also been on her association board. She's been president of her board. She's very, very knowledgeable on this subject. I have been active in many nonprofit organizations, including the Miami-Dade Bar, and I am very proud to say that my organization, the Miami-Dade Bar Association, which is lawyers in Miami-Dade County, has been authorized by a unanimous vote of the county commission to create a condo and HOA information and dispute resolution program. So you will soon be learning about the Miami-Dade Bar's dispute resolution program for associations that is being funded by the county and is in collaboration with the DBPR. So we're very happy about that opportunity that will help, we hope, everybody in the community understand what their rights are and what they need to do to enforce those rights. So thank you very much for your attention, and now we'll take your questions, sir.
unfortunately, we're not going to be able to take questions because they're running behind. So they've asked us to limit our questions to the back. So you're welcome to come over to our table. And just very quickly, I was in your position, and I was also, as an attorney for 20 years, suing on behalf of condo and HOAs. I came over from the dark side to Jane's firm, because one of the things that Jane does is she makes sure she's advocating for the little guy. She is making sure that she is representing homeowner and condo owners against what we would call the dark side, okay? So please definitely consider Jane Muir and Associates. We're in the back. If you have questions, come back to us.
Thank you. Thank you, everybody.
So could we have AR Law Group come up, Mr. Pablo Arriola?
Hello, good afternoon, everybody. It's a pleasure to be here. I want to thank you all and congratulate you all also for showing up. I'm sure none of you have anything else to do on a Saturday morning, and you took your time to come here to learn and hopefully to provide something back to your community. So I congratulate every one of you. Okay. So I was asked to cover fees, late fees, interest, and how payments should hopefully apply in your community. Do I have a clicker? Oh, should be here. I think it's this one here. Okay. So the objective of my presentation is basically to answer two questions. Can my association charge a late fee and interest? That's sort of 1 in 2. Better? Yeah. And if so, is there a limit? How much is the fee that it's allowed to be charged? And then how payments apply to my ledger, right? Everybody has a ledger. And sometimes you receive late fees when you don't pay, or sometimes you don't receive late fees, or some months you do, some months you don't. That happens in, I don't want to say every association, but it does happen in almost every association, unfortunately. So one of the first things we need to do to know if my association can charge a late fee or not is to actually go to Florida statutes. Florida statutes has the answer. We have for condominiums, Chapter 718, for cooperatives, co-ops, 719, and for homeowner association, 720. I'm only going to cover 718 and 720 today, which are the most common ones. Florida Statute, Chapter 718, 116-3 actually says, assessments and installments on assessments which are not paid when due bear interest at a rate provided in the declaration. It's very important, the rate may not exceed the rate allowed by law. If no rate is provided in the declaration, interest accrue at 18%. So the association can charge no more than 18%, even if it says so on the declaration. Now, what's very important here, it says that if provided in the declaration or the bylaws, the association may also charge a late fee, $25 or 5% of the installment. What's very important here, and what attorneys do when we come across almost every statute that we need to read, is understand exactly what it says. Two very important factors here are that they need to be provided in the declaration. It says provided, the rate provided in the declaration, and if provided in the declaration or the bylaws, right? So if the declaration or the bylaws do not provide for either a late fee or interest, the association simply does not have authority to charge either one of them or both. Sometimes they do, sometimes they don't. So the next step, well, let's review 720. 720 has very similar language at the rate provided in the declaration, and it's basically the same thing. It's up to 18% of interest and $25 or 5% of the installment, right? So the actual assessment. And this applies per assessment. So if you have a regular monthly assessment and a special assessment and you don't make the payments, you could be charged per assessment. So it would be either $25 per each or 5% if they have different amounts. Again, it also tells you to go and look at the declaration for the bylaws. Now, the next step then will be obviously to go check out the documents. Now, what I did here is I provided, this is a copy paste from some of my condominium and HOA's clients. Here, for example, assessment and installments that are unpaid for 10 days after due shall bear interest at the rate of 10%. So can they charge 18%? No, they can only charge 10% per annum until paid. At the sole discretion of the management firm or the board of directors, I prefer the board of directors, a late charge of $25 shall be due and payable. So here, if the association board has decided to charge a late fee, they can also charge a late fee of $25. Now, it's important that the association has records of that decision. So they need to have the agenda, they need to have the minutes, it needs to be a topic in the agenda. So they must have a record of when the association so decided to charge the $25. They can't just change management company and out of the blue start charging late fee only because this management company also charge a late fee on other associations. It has to be a board decision, there needs to be a record of that. Another association, penalties for delinquency. Any assessment that is unpaid for more than 30 days after the due date shall bear interest at a rate of 18%. That's it saying about late fees? No, this association cannot charge late fee. So if you live in this condominium or HOA and you make a late payment and you charge a $25 late fee, this association does not have authority to charge a late fee and you should complain. Next one, this is from an amendment. I wanted to specifically show an amendment because the association was not able to charge before. It amended its documents, I'm sure through a process of approving with the participation of the members. And it voted for the late interest, if not paid within 10 days, and a late fee as well. But it's very important, the language has to be there. And this cannot be on rules and regulations. Rules and regulations do not override the declaration, right? Declaration of condominium, of declaration of covenants and restrictions if it's an HOA. So the governance documents are the declaration and the bylaw. Those two dictate what the association can and cannot do. If it's authorized to regulate other things that are not covered in those two documents, then we create some regulations, but they do not come each other. So, to answer the question, it depends. Because I cannot give you an answer. Can the association charge a late fee and interest? It depends. We need to look at your specific governing documents and see if there's authority to charge that late fee and that interest. So it's very important if you're on the board, when you go back to your community, you take a look, consult with your property manager, and if you are charging a late fee and interest that you're not authorized based on the governing documents, make sure that they're not need to be waived. They need to be removed. You're not waiving something you're not entitled to charge. It just needs to be removed. And if you're a homeowner and you are charged late fees and interest, make sure if you don't have, the association doesn't have the authority to do it, make sure that you let them know. You can always consult obviously with an attorney, but if they don't have authority to charge that fee, cannot be charged. So as to the next question, hopefully I'm going fast so that we can catch up with today's programming. How do payments apply? Florida statute. We always start with Florida statute. The second part, I covered the first part when how much of the fees can be charged. This is the second part of that same statute. It reads, any payment received by the association must be applied first to any interest, then to any administrative late fee, then to any cost and reasonable attorney's fees or admin costs, letters sent to you, and then to delinquent assessment. And it says here, regardless of what you write on the check, right? So if you're 3 months behind, let's say January, February, and March, you just didn't pay. And here we are in April, you can't just write a check for the $500 of the monthly assessment and say, this covers April, don't charge me a late fee. It just doesn't work that way. It's going to be applied first to interest, then to late fee, then to any administrative fee or attorney fee if it was sent to the attorney, and any remaining of that payment then applies to the general balance that will be assessments. Same thing is with HOAs on 720. So here is how you apply the payments. Let's say January, right? For January, you have, I made it simple, $250 a month as a regular maintenance. It goes unpaid on the 11th day. If the association can charge the fee, you have $25 of late fee. Here comes the end of the month, you apply the interest. Now, interest can only be applied to assessments. You can't charge interest on late fee. You can charge interest on legal fees or administrative costs, and you cannot charge interest on interest. In other words, you need to separate the assessment, and that's what you charge interest on. So here we are in February. Now we have a new regular maintenance, and the balance is now including the $528.75, includes previous month's assessment, late fees, interest, and the new assessment. Here comes the 11th. On the 5th, the owner decides to send a $500 payment. So on the 5th of the following month, the owner says, well, here goes my $250 for January and $250 for February. But this owner didn't pay the $25 late fee from last month or the interest for last month. Now, if your association has the authority to charge late fees and interest and is not doing this, then the association is now not collecting $28.75 that's entitled to collect. In fact, depending on the language on the governing documents, it cannot be waived. My suggestion to my communities is always, do not waive it. Why? Because if I waive it for John, I have to waive it for Susan. And if I waive it for Susan and John, now I'm going to have to waive it for Peter. And then why do we have a fee in the first place if I'm going to waive it to everybody? Right? This is a penalty for those that don't pay on time. The association has to pay its vendors timely, so it's important that everybody also pays timely. So late fee applies again. Why? Because the $500 first cover the interest, then cover the late fee, then cover the any remaining, if there's any other penalty for attorneys or letter that was sent, it will cover that letter. And then any remaining balance goes towards the assessment. So here on the 10th, the owner was late. The $28.75 that was in the balance is not late fees and interest. It's maintenance. Late fee and interest was already paid with the $500. So now the account remains late. $25 late fee applies. Here we go into the following month. Now there's 38 cents on the $525 balance. So now we have maintenance for March. We go on to sending a NOLA, Notice of Late Assessment. Most associations or property managers will charge a $25, sometimes $10, sometimes $15. So that is now an administrative fee that will be paid before the maintenance is paid. So now you have here in March, and now pay attention to this, you have really is $750, right? 3 months, $250. So if your association can charge a late fee and interest, you're not collecting the difference that you're entitled to collect. In this case, will be $75.38 that the association is not collecting. This is only on 3 months, 1 unit, right? So if the association needs the money, this is revenue that the association is absolutely entitled to collect. That's not collecting. Because at this point, we have 3 months worth of payments, $750, $250 a month for 3 months. But there's still a balance of $75.38 that if you're not charging these fees, it's just not being collected. We move on to April, $250 the new month, and I think that's how far I go. I made it through today. Today is the 12th, so on the 11th, the $25 actually apply, and now you have a balance of $351.51. When you look at the ledger, if you didn't charge these fees, there's only will be $250 for the 1 month that remains unpaid. But really the balance is $351, right? So this is how payments should apply. Again, many associations are not applying this correctly. Some other associations are not entitled to collect and they are charging them. So just make sure when you go back that you review the governing documents, you consult with an attorney. And again, this is on both sides, right? I represent homeowners and I represent associations. Regardless of who I represent, this needs to be done right. So if the association should collect the fee, the association should collect the fee. If the association is not authorized to collect it, then it cannot be collected. It's just that simple. It's just how the law applies. Again, I believe we're not doing Q&A because of the time, but we'll see here on the side if I can be of assistance. Be more than glad to talk to you. Thank you very much.
So we would like to welcome Senior Law. How do you? Okay, here I'm gonna put the presentation.
Okay. Hi, good afternoon, everyone. How's everybody doing today? My name's Carolina Shear. This is my partner, Alessandra Stivelman, and we're partners at Eisinger Law. We're a full-service boutique law firm that specializes in condominium community association law. Hablamos español. Vamos a hacer la presentación en inglés, pero también podemos tomar preguntas en español.
Today we're going to talk about tips and tricks to avoid election fraud. So a lot of what you've heard, a lot of what you heard today talked about how to get information as an owner, and a lot of times it's easier to get that information when you're on the board and you take control of the board. So we're going to talk about the election process. We'll hit on recalls real quickly, but we have a lot to cover, so we're going to go really fast, and then we're happy to take questions here or after. Oh, okay.
Just brief disclaimer, no legal advice is being provided. Okay, so the election process. How many of you are in a condominium? Raise your hand. How many of you are?
This work? I don't know. Woo woo. Yeah, we can both talk at the same time. Whoa.
No, we can't.
Yeah.
No, disconnect. Hello? Okay. How many of you are in an HOA? Raise your hand. Okay. So the processes for elections for condominiums and HOAs differ slightly. I'm going to explain the condo concept. Alessandra is going to explain the HOA concept briefly. So in the condominium context, the condominium elections are governed by Chapter 718 Florida statutes. And there is a specific and procedural requirement that has to be followed. At least 60 days prior to the annual meeting and election, the association is to send out a first notice of annual meeting and election informing the membership of the upcoming election. You're required to have an election at least annually, and your particular governing documents will specify when that election should be. Some associations will specifically say your election should be held on the third Tuesday of the month of January, or at such other time as the board reasonably decides. So you have to take a look at your governing documents and confirm when your election should be. Once the first notice of annual meeting and election comes out, every owner who is eligible to be a candidate for the board can submit a notice of intent to be a candidate at least 40 days prior to the date of the election. Okay? Now, who is eligible to be a board member? Generally speaking, if you are a member of the association, a unit owner, and you are not delinquent in the payment of your assessments, and you have not been convicted of a crime, and have not had your civil rights restored, you will be eligible to serve on the board of directors. Note that some associations actually allow non-unit owners to serve as board members, but it's very document specific. Also, okay, so once you submit that, at the 35-day mark, you can submit a bio sheet, which then gets sent out at least 14 days in advance of the annual meeting and election, together with a ballot, everyone's bio sheets, and the second notice of annual meeting.
Wait, and importantly, the outer and inner envelope. So the big difference between HOA and condo elections is that condo elections, you are not allowed to give away your proxy. You can't tell somebody else to vote on your behalf in a condominium. In an HOA, you can. In a condominium, you're required to do the 2-envelope process, where you have the ballot, you fill out the ballot, it goes inside of the inner envelope, then the inner envelope goes inside the outer envelope, and the outer envelope needs to be verified before you actually start counting the ballots.
So it's a very regimented process that we follow. I know when we go and we monitor elections, we make sure that we explain this process to the owner so that there's no mystery. Yes. So the it is not appropriate for the property management company or the property manager to campaign on behalf of any.
Right, but going door to door. So we'll get into some of the issues in a little bit, but we have.
It's not appropriate.
Yeah.
No, it's not appropriate. It's not permitted in the rules.
The property manager cannot sign the outer envelope.
It is not an appropriate practice.
Okay, so. Okay, hold on, because we have a lot to get through, and then I promise I'm happy to take all your questions. So HOAs are a little bit different. For HOAs, it's almost like it depends what your governing documents say. There's very little statutory orientation for HOAs. It defers you to look at your governing documents. There is no 60-day, 40-day, 35-day notice. Usually it's 14 days, if not less. And the big thing about HOAs is that the statute used to say you have to take nominations from the floor. So in HOAs, you don't submit the notice of intent in advance, generally. You take nominations from the floor. The statute was amended a few years ago to say you don't have to take nominations from the floor as long as you have a process in place that allows for nominations to be taken in advance. Now, sometimes your HOA documents will actually say that you have to comply with secret voting requirements. The HOA statute says if your governing documents say that, then you have to go through the 2-envelope condo process. So a lot of times I see HOAs that are running this election completely wrong. I've seen management companies run an HOA like a condo and vice versa. So it's very important to take a look at the procedures and compare them with the statutes to make sure you're following the right process and that you as owners wanting to be on the board have the appropriate notice. Not only do you receive it by mail, but that it's posted and that you have the necessary information to actually vote and attend the meeting.
So going back to your question or to the comments, the law is not perfect. You have to remember a lot of association law is a creature of contract, meaning what your governing documents say and what the statute says, and sometimes they don't align. Campaigning, right here, campaigning is not prohibited with regard to elections. With regard to the management companies, you're technically not supposed to be utilizing association funds by the manager to campaign on behalf of any person. I know it doesn't fully answer your question. It's not illegal for a manager to say it, but it's not correct for them to do it either. Does that make sense? Technically,
Yeah.
the argument would be that That's why it's inappropriate. Because
But remember, a lot of times managers go around and ask owners to sign limited proxies in order to get amendments passed. So it really depends on the community, the intent, and you have to look at the whole picture. It's impossible to give you a yes or no without looking at everything else. But there are a few really common areas where we're both election monitors, independent and appointed through the Condominium Ombudsman's Office, and we run elections for our clients all the time, and we see a lot of this. There's a lot of ways for owners to interfere with an election, and there's a lot of ways that associations can ensure that an election is run properly.
so one of the big ones that we see is the use of proxies. For condominium associations, you cannot use a proxy for an election. The only time you would see a proxy at a condominium annual meeting would be for purposes of establishing quorum for the meeting, but it is not used for elections.
Wait, one other thing as far as quorum for condominium elections. Your governing documents may say you need a majority of the owners in order to have a membership meeting, but the statute only requires that you get 20%.
To look at everything on a case-by-case basis to determine that. Yes. So 20% of the eligible votes.
So one of the things that happens after you guys submit all your envelopes in a condominium, there needs to be a verification of the outer envelopes. So we need to make sure that there's a signature, that we know that the person who voted is the voting member, and ultimately that it's properly identified that that's a voting member for that unit, right? So if you have 20% of the voting interest submitting eligible envelopes, outer envelopes, then you can open them and hold an election. 20%.
20%. So if you have 100 units in your condominium, you need a minimum 20. One outer and one in.
Okay, so there is a ballot, a little envelope that the ballot goes into, and then the ballot goes into another big envelope. And then the big envelope is the one that you have to verify on the outside.
There are some exceptions.
Yeah. So one of the recommendations that we do for associations is this is not a concept. Whoa. Okay. This is not a concept that everyone really understands. To us, it's like the back of our hands because we do this day in and day out. But a lot of board members and management companies don't really understand the purpose of this and how to run the election properly. So we recommend, and we have done this as a result of fraud in different elections and being retained after to communicate with the membership, to hold a workshop where after you send the first meeting, you actually hold it via Zoom or in person. You have the actual documents that the owners are going to receive in the mail, and you run through and you explain what these documents mean. Because there's a lot of confusion. People don't know how to fill out proxies or voting certificates.
So then I saw a gentleman over here with his hand raised, but I'm going to say something else. There's also something called a voting certificate. A voting certificate is not a proxy. A voting certificate is a document that indicates who the designated voting member on behalf of a particular unit is.
Okay. Right. I can't attest to your specific situation, but ultimately once the voting certificates are in place, they are valid. I mean, they exist. You have to refer to them. Whether they're properly filled out or not is a whole different story until a new one is submitted.
Okay, we have a question from this gentleman over here. Yes, sir.
My question is, if I'm a property owner, but I don't live in my association, can I run for the board?
Absolutely.
There's nothing in the law that restricts you from running for your board if you do not reside. Even if your governing documents have that restriction, it's very likely it's not enforceable.
So another issue that we face a lot is voter intimidation and campaigning. So let's get something straight. Every condominium is a tiny little country with its tiny little government and its tiny little politics and its political parties and people with different opinions. Campaigning for an annual election is not illegal. You are allowed to campaign. What you cannot do is engage in fraudulent practices. What the board of directors cannot do is issue correspondence and communications as a board endorsing candidates or utilizing association funds for purposes of campaigning. Everything else is pretty much fair game.
Okay. In regards to that and campaigning, I'm going to start speaking really fast because we just got a 2-minute warning. But ultimately, if you're in an HOA, okay, sorry. Okay, so I won't talk that fast. So in regards to campaigning, I have an HOA. We've established rules and regulations and procedures for elections when the governing documents are very bland and don't provide much information. And one of the restrictions that we recommend is not restricting campaigning, but allowing the members to decide whether they want people coming to their doors or not. So, you know how like in the Brazilian restaurants, you have the green and the red if you want more meat to come or not? You can put one of those on your door. Like if it's red, then you're not allowed to campaign there. And that's a way for the associations to protect against the proxy wars, against the campaigning, for owners that don't want to be disturbed. And then you should also consider doing a town hall and an opportunity for the candidates to speak so that you avoid the campaigning and misinformation.
No, you're not permitted to be utilizing association funds for purposes of campaigning. If I am, there are recourses available. We're not going to discuss your specific circumstances, but you're not supposed to utilize association funds for purposes of campaigning.
Yeah.
All right. So, electronic voting. Electronic voting is a tool that came into play and actually was very beneficial during the pandemic, particularly because we had many unit owners who were not able to come to the property.
But and just as a precursor, this is different than electronic notice and electronic participation. We're talking now specifically as to electronic voting. We can touch on notice and remote viewing participation, etc., as well for Zoom and such, but this is only electronic voting.
So the benefit or the goal of electronic voting was to create more of a smoother process, time-saving process in connection with the ability to vote. The statute has specific requirements for opting in and opting out of electronic voting. It also has specific requirements for the voting portal or platform that you hire. To adopt the electronic voting process is relatively an easy process. The process requires that the board of directors mail out a meeting notice and adopt a resolution with appropriate instructions for opt-in and opt-out. And it's a 14-day notice. It's very simple. The difficult part about electronic voting and what I've found has its pitfalls, if it's not properly managed and organized and the documentation is not properly administered, the voting process fails. So it's really important that if you want to have electronic voting, that your management and your board keep adequate records and files, and that you as unit owners ensure that your information is correct and updated all the time.
Right. This is where the electronic voting allows gaps for fraudulent actions, because if your management company or your board is not confirming that the person's email that was provided is the authorized voter for that unit, you can get a lot of funny business going on with the electronic voting. Another thing to keep in mind is only because you adopt electronic voting does not mean that owners are prohibited from voting by ballot. You're not allowed to require electronic voting. You only give them the option to opt in. If done correctly, it's great because it literally cuts the meeting times in half. So it's going to save you money with attorneys, with managers. It's going to save you mailing, because a lot of times when they opt into electronic voting, they can also opt into electronic notice. And then you don't necessarily need to mail everything to everybody, and saves the association in postage.
Yes.
Hello, everybody. Great presentation. I have the first question. Our documents, like many of us, was done 20, 25 years ago, where electronic voting never existed. So in the documents, it's not forbidden to electronic voting.
It's forbidden?
It's not.
Oh, right. But the statute allows you to adopt it, even if it's not specifically referenced in your governing documents.
Some candidates, what they do is they take a picture of a send that to the owners of the home that are maybe outside the country. They ask just they take a picture back and present that as a proxy. Is that valid?
So there's nothing that requires that the association actually have the physical proxy if it's sent via email, because there's no secret voting. So this is different. They can't do that with the outer envelope in a condominium scenario. They may or may not be able to do that. It would depend on the validity and whether we can verify and consider it valid proxy, but it could be done because it doesn't have to be secret, so you can email it.
There has been discussions, nothing is out, but there has been discussions about reforming the HOA election process. Right now, there's nothing available, so the answer right now is no.
So there's a few safeguards and pitfalls of electronic voting. A few years ago, it was only for the high-end, very large associations because it was only attainable to them. There are tons of vendors out there. Make sure you go with a Florida vendor and one that complies with the statutes. And that another tip would be to ensure that the vendor that you use has reciprocity with your management company for record purposes, so you don't have to pay for someone to re-input all the information and do all that, which does allow for mistakes and allows for the possibility of fraud there as well.
Sí, mi pregunta es, mi mamá es dueña de un apartamento en un condominio. Ella tiene 80 años. ¿Está bien si yo participo en las elecciones para hacer el board? ¿Ella puede darme alguna autorización para eso?
Her question in English is her mother is 80 years old and she is the owner of the unit. She would like to know if there's a way for her to be able to serve on the board on her behalf. One, it depends on what your governing documents say. If your governing documents do not permit non-owners to serve on the board, then most likely you would not be able to serve on the board.
She could add you to the deed, and then you would be an owner, and then you would be able to serve on the board. But ultimately, you can't, as a director, you can't.
Most documents will require you to be an owner. Oh, sorry, perdón, no me di cuenta que estaba hablando en inglés. Lo más probable es que los documentos gobernantes de la asociación indiquen que para poder ser miembro de la junta directiva tenés que ser propietario. Entonces, lo más probable es que usted no pueda servir como miembro de la junta directiva sin ser propietaria. Hay ciertos documentos que permiten que un miembro de la junta directiva no sea propietario, pero hay que ver su caso en particular.
Bueno, a few. I don't think they can do a power of attorney for.
No, generally the power of attorney would not apply. Yes.
It's a fuzzy line, and that's where it's a gray area, right? And we need to know all of the circumstances because nothing is prohibiting an owner. You guys, as owners, have the right to free speech. You have the right to be in the common areas. Unless your governing documents or the rules specifically prohibit it, there's nothing that would prohibit you in the law from going door to door and talking to your neighbors. That's a great question. It's on a case-by-case basis.
No.
So remember, you guys as owners have an obligation to be educated. You have to read your documents. You have being naive about what your obligations and just having someone bring something to you and say, hey, vote for me. That's on you guys. Educate your neighbors. We offer tons of free education classes so that your neighbors know that they shouldn't be signing something that someone going door to door is doing. Okay. No, exactly. I mean, it really comes down to education because what may be deemed intimidating to one
Regulated by the statute.
Yeah. What may be deemed intimidation to one may not to the other. Obviously, this occurs a lot more in older communities and in communities where individuals don't really understand what they're voting for, but I don't know that it gets to that point of being intimidation. Okay, so
Unfortunately, everything is on a case-by-case basis. It's on a case-by-case basis. It's
at the end of the day, yeah, no one's holding a gun to your head and telling you have to vote this way. So you have options. It depends.
It depends.
It depends, guys. These are case by case. It depends on the circumstances, but this is not something that I would say is generally deemed intimidation. We have to finish. We're going to take one more question, but the election monitor is a really great option for owners. You can petition, even though there's currently no ombudsman that is overheading. The ombudsman office is still there, and you can petition and get an election monitor appointed. And there's changes in the laws for HOAs, and scan there for our PowerPoint. Thank you, guys. Sorry we couldn't answer more questions, but we'll be happy to over there.
Thank you. It's already on.
It's on? Yes. Good luck. Good afternoon. Can you hear me? All right. My name is Reynaldo Castellanos. I know there's a lot of noise outside. There's a lot of noise in the back. There's a lot of noise with a coffee grinder. So I'm going to try to speak out so that you can hear me. But if you do not hear me, please let me know. I am a condominium attorney, homeowner association attorney, and real estate attorney for many, many years. Imagine starting back when at the law firm doing declarations, writing the bylaws, writing the articles of incorporation, writing your declaration, rules and regulations. That's how I started condominium many, many years ago. And I still do them today for developers. I represent associations, but I represent a lot of group of unit owners. I've been approached by many unit owners who want to recall, want to remove a board because of what they're doing, which is usually no transparency. But my topic here today is spending association funds. Okay, and an association is a lot like a city. In other words, you have citizens, constituents that vote in elected officials and then pay taxes to those elected officials to spend your taxes, which is pretty much what an HOA or a condominium association is. You are the unit owners. Thank you. I told you there's a lot of noise outside. You are the unit owners, so you are the constituents. As unit owners, you vote in the board members. And like any government of representation, once you vote somebody in, you gave them all your power. You gave them all your power to spend your money, just like we do with Washington, okay? In Florida and Tallahassee, we elect them, they get to spend our money, and they have to pass budgets. The budget is pretty much where they sit down like we do in our homes and they say, well, I tell my wife, what are our expenses for next year? What are we going to have to pay for the next 12 months in 2024? We have the mortgage, health insurance, property taxes, car, you name it, fuel, schools. All these are my personal budget. All right, so in an association, the board has to look at what is the incoming budget? What are you going to need money for? And usually, it's just the contemplated expenses. What you know are the expenses, the checks that are coming out of the operating account for the next 12 months. That's your budget. And in Florida, condo and HOA associations are not for profit, which means it is a skeleton budget. You only put in there what you have to pay next year. You don't fill it with fluff. You can account for some contingencies in case you have bad debt, a few unit owners don't pay or they lose their units. You don't have every check for every unit. Then you have a little slush fund, a little extra contingency you could put in your budget. But you can't load it with things that are not common expenses. Common expenses for the maintenance, repair, replacement, and protection of the common elements. The common elements that everybody owns. Because in a condominium, you own a little portion of every common element there is. In an HOA, the HOA owns the common elements, but you own the HOA as a shareholder, let's say. Okay? So that budget is pretty much only for common expenses. With that in mind, you as a unit owner should be very, very interested in seeing what's on the budget. And by law, like he said, 2 meetings a year that a lot of people combine into one: annual election and budget. So that one meeting, which is all that the statute requires right now, has to accomplish 2 things. Give the unit owners the right to elect a new board and have the board pass a budget. The budgets are not approved by unit owners, okay? The budgets are approved by the board. So if you have now a budget for 2024, most of the budgets in Florida do not include reserves. A lot of associations have been collecting reserves for a long time, and a lot have not. But the law is going to change on that, and changed already, and it's going to be in effect January 1st, 2025. Okay? So if you have your common expenses, you list them all for the year, and every month you pay them, then you should be okay at the end of the year, because the money that came in was accounted for with the money that went out. Perfect math. There could be a little money extra or from the year before, but usually that's the way you have to run your budget. What are not contemplated, expenses that come up during the year, all of a sudden, emergencies, pipes broken, increase in insurance policies, because the policy didn't start January 1st with your budget. It started in April when the old one expired. So now, if it went up 18, 20%, like they approved last year and the year before, average 15, then that's a big hit. If you're paying $500,000, you're going up to $700,000. Some have doubled. Some of these companies, you were paying $600,000 last year, and the board told me, Ray, they want $1,800,000 this year. I'm like, what? So imagine the amount of extra money that has to become common expense for all the unit owners. Okay? So once you have your budget, you know what you're going to be spending money on next year. But part of the budget is bids, right? Part of your common expenses could include landscaping. And when you got to collect for landscape for 12 years, you go to a landscape company, or at least 2, like the law says, at least 2 for competitive bidding, and try to get a good price for the incoming year. Same for security guards, for insurance.
Wow. I said, everyone in this you must have done yes. I said, no one can now. And
when they're spending money on boards that they're not telling the owners and the owners have no information about it. Maybe it's absolutely legitimate expenses. Money came in and we paid what we had to pay. But sometimes it's not. And sometimes there's fraud. And one of the big cases we all spoke about today was the hammocks. The hammocks is a huge, probably the biggest HOA in the United States that committed fraud. First one board member, and as another couple of years went by, all board members got involved. I guess everybody wanted a little piece for themselves. They all got arrested. In 2017, I, as the attorney for 3 condo associations inside the hammocks, went with presidents and board members to visit Carlos Luffy, Detective Luffy from Economics Crimes Unit. And we went there to start a case against an HOA called Hammocks Community Association. We started that with an intake sheet, and they started the case. We took them some evidence. They didn't give us all their financial records, but we found a few. We found a couple that was very, very irregular. In Orlando, a private investigator, $90,000 on an American Express card that they had a card. They had an American Express card at the HOA. $90,000 on a private investigator? What is that about? That was one of the things. Several CDs at banks had been cashed, had $500,000, $1 million, and we didn't know what they were using that money for, and they wouldn't tell us. So in 2017, we started a case at the Economic Crimes Unit with Detective Carlos Luffy and his partner back then, Yvette Lopez, who has since retired. Okay? After meeting with them and taking them sufficient information, they went and started subpoenas, and they weren't getting answers. They bumped it to the state attorney's office with John Predicles and Mary Ernst, and we started meeting with them and taking them the information, okay? Because we don't have the resources that they have to go ahead and subpoena. And a funny story about subpoena powers. The state attorney has subpoena power to go to the HOA, to a bank, to the PI in Orlando and say, show me these records. Well, they did. They went to the HOA and they requested records. And the HOA did not turn them over. They said it's going to cost at least $50,000 to produce all these records. So you got to pay us $50,000 to produce the records. They spent over $500,000 fighting to not give those records that they said cost $50,000. But they spent $500,000 in attorney fees to stop the state attorney from getting them. But they got them eventually. 2018, 19, 20, and 21. They finally arrested the president. And in 22, they arrested the rest of the board. Okay? It takes an effort, and there are laws that maybe have to be put in place and some changes. But remember, they're spending your money. They're spending our money when we're taxpayers in a city or a state or federal government. And if you want to start somewhere, getting involved with your association, if you want to fix your association, if you want your property to be maintained, painted, roof fixed, and everything else taken care of, you have to start with your budget. You have to start knowing how much money is coming in and where is it being spent. And if they don't tell you that, you have rights. Every unit owner, one unit owner, has rights. And I've done this many times. Under the Condominium Act, we do a request to inspect records. We want access. The statute says that within 10 working days, I must be given access as a unit owner to review these records. And I could go in with a copy machine or a scanner and make copies of everything. What's everything? Well, everything on that budget that you're paying, I want to see the file, the contract, and the checks that you paid them and the invoices for all of that. I want to see your bank statements. I want to see your monthly financial statements and your year-end financial statements. That's if you don't get that, like John Predicles says, that's a red flag. That's one of the first things that sends up a warning sign, like say, hey, why can't I see that? It's my right under Florida law. So if you don't get it in 10 days after the notice that you're going to take them to arbitration, if you don't get it, you file an arbitration action. Of course, a lot of people do it on their own. A lot of people do it with attorneys. But in arbitration, my experience has been that they don't give a break to the association who's refusing. They will give you an order most of the time, ordering them to turn over those documents. HOA, which a lot of HOAs here in Doral, HOA is different, and that's one of the laws I hope Representative Porras can change. HOA is different for records request. You put in a records request and you want access, same 10 days. But if they don't give it to you, you cannot go to arbitration and you cannot go to injunction in court directly. You must go and offer them to mediate. So you have to send them an offer to mediate this. We want to mediate this because you didn't turn over the records. Well, they have 20 days to accept mediation, and if they don't, then you can go with legal action. However, if they accept mediation, they have up to 90 days to complete mediation. So that HOA law is terrible compared to the condo law for records access. And that's one of the changes that I think should come. The other big change that I'm hoping to talk to Representative Porras on is that if I'm a corporate entity, whatever homeowner association, whatever condominium association, Inc. in Florida, and I have to keep financial records monthly and yearly, then every penny that comes out of my account, my corporate account, must be to an entity that has a tax ID number or a social security number. It cannot go to Pepito Perez, who did $5,000 land work, and there's no trees and no gravel and no grass. What happened to the money? Who knows? But he has no social security number, so you can't go against the IRS and see if he put it on his returns. You can't go against a business who may have gotten a $50,000 check if he doesn't have a tax ID number. So if the law would require those two things for HOAs, you'd have a lot more power. One is that HOA records requests be treated like condo records requests. 10 days, if you don't get them, you can go and start your arbitration. And every penny of your money that's spent of association common funds must go to a social security number or a tax ID number. Those are two things, and I'll tell you why before I finish. One of the ways that they were stealing money at the hammocks was the president's husband created a straw company. The company opened and all that, and $100,000 check for no services, just to take money out of the account. Well, obviously, they caught it, okay? But without an easy paper trail, you're not going to catch it, okay? So if we have an opportunity, I don't know if he's still here, this is one of the things that would help a lot in the change of the law. Remember, what I'm talking about is our money. When I am in an HOA and I got to pay $400 a month, where are you spending my money? I have the right to know every penny of my money. You don't get to hide any of it. Judges are not letting them hide anymore. Arbitration sections are not letting anybody hide. This is coming now because of participation by owners. And I'll tell you, it's sad because I go to a lot of condo meetings and I know all the other attorneys here do the same. And empty chairs. Empty chairs. Today's the budget meeting. We're approving a $500,000 budget. And the chairs are empty. What is this? That's the most important thing, the apathy. If people start getting involved, and looking at their budgets and seeing where their money's going, you're going to have a much better solution here in your hands, because you're going to detect it immediately, not 7 years after, okay? And you're going to be able to do something about it. The other big item is when they get a loan for construction. We're doing new roofs, it's $1 million loan. Well, if you have 100 units, that's $10,000 per unit. That's a lot of money, you know? Maybe you could pay it in 3 years or 7, but it's still $10,000. Well, what are you spending the money on? What do you need $1 million for? Well, the 40-year recertification, 50-year recertification, or just a new roof and new pavement and new painting, which is regular maintenance items. Okay, well, you're the board. Are you doing this professionally? What do you mean professionally? Yes. You want a new roof? Okay. You want to do pavement? You want to do lighting? The city is requiring it for the 40-year recertification. Do it professionally. What do you mean professionally? Well, first thing you got to do is get an engineer who tells you the condition of the roof, the pavement, the walls, the electrical, the lighting. Okay? And that engineer report is the one that the board receives and says, okay, let's bid out the roof. Let's bid out the electrical. Let's bid out the painting, the lighting. And let's get 2 or 3 bids, a responsible board. Let's get 2 or 3 bids, 4 bids, and pick a good roofer with a good reputation, with a license and insurance, and let's sign the contract with them. Okay? Lot of problems occur when a roof is a $500,000 roof, and they go and get somebody to do it for $900,000. And you're like, wait. If in Miami all the roofers would do this roof for $500,000, why did you pick somebody for $900,000? That goes back to the fiduciary duty, the obligation to act in good faith. Okay? But these are the ways that you could understand when they're trying to take money. Somebody's trying to take money. You may not ever be able to prove it. You may not be able to prove it because if the roofer gets $900,000 and gives the president a 100 in a Publix bag, nobody is ever going to find out, because only 2 people know it, and they're not going to turn each other in. But it doesn't matter. Not all of this is theft. Not all of this is fraud. But you have to keep an eye on the budget. You got to keep an eye on your money. Okay? So I know a lot of people spoke about other things, but one of the most important things in every government, and this is a mini government, every HOA and every condo is a mini city. Even if it's 90 units or 3,000 units, it's a little city. You elect people to spend your money. They tax you. That board taxes you. That's why they can lien and foreclose, because it's a tax. You have to pay your tax. It's called assessment. And if you don't, you get a lien and a foreclosure. I'm going to close with one thing that I don't want people to have a misconception. Lately, because of the changes in the law, the increases in insurance, the mandatory reserves, you do not get to pass a budget and say $100 per unit per month. You have to include the reserves for roof, painting, and anything else in that structural integrity reserve study that the engineer is going to say, start saving money, because you either pay an extra $50 a month for 10 years, or at the end of 10 years, you get a $10,000 special assessment. Okay? So now that that's coming up, be aware that a lot of the increases that people are experiencing is because of the increases of costs all around Florida and the mandatory reserves that are going to start January 1st. Okay? I hope that was helpful. I hope it enlightened you and opened your eyes a little bit so that you start paying attention to where your money's going. Okay?
Thank you very much, everyone. His table is right there if you want to ask him any questions. Right now, who's coming up is Gomez Law. He's going to present right now. So we're going to wait on for him, but thank you so much. Again, if you have any questions, his table's right there. Law Offices of Reynaldo Castellanos. Thank you, everyone.